So that was the period before, in 1641, when the king had no alternative. He wanted to fight a war in Scotland, had no money, so just had to bring the Parliament back for some taxation. And the Parliament then took a stand, made war on the king. Now, the first thing they did, this is great, was abolish the Star Chamber. The Star Chamber was the king's personal court, in which a few lickspittle judges and his lickspittle bishops would order torture, and had ordered the torture that I've described. And the Star Chamber was abolished in 1641, and never since then has there been torture permitted by law in Britain. Henceforth, torture was something done by the French. And they did it a lot for several hundred years. The judge would, in the Inquisition, would approve the degree of pain that was exacted on poor suspects. It was part of the European inquisitorial tradition, but it is one of the great boasts of the common law that torture was abolished forever in 1641, and it's a matter that the House of Lords, our highest court, took notice of a couple of years ago when they decided that torture evidence obtained through torture in Algeria and Morocco and so forth would never be admissible in an English court. Now, the next thing that Parliament did was to establish on 15th of January 1642, a real red letter day for lawyers, they established the independence of the judiciary. Previously, judges had held office at the king's pleasure. After that point, they held office subject to misconduct. So that was the second great achievement. Of course, there was the sovereignty of Parliament. There was a degree of free speech. At first, Parliament abolished all licensing exercises, and there was a vast incontinent flow of pamphlet literature, wonderful stuff in the 1640s. When the Presbyterians in Parliament wanted to reintroduce licensing, the great poet John Milton published the Areopagitica, perhaps still the greatest argument for free speech. Give me liberty to know, to think, to utter amongst, above all liberties. He equated censorship with the exploits of the gallant farmer who thought to keep out the crows by shutting the park gate. That was Milton's wonderful description of the censor. And so we do get a great deal of freedom of speech. We get the Levellers, who were the first really investigative journalists, who some of them got done for treason later, but they would investigate anyone. They investigated the king and the royals and condemned them, then they investigated the Presbyterians and condemned them, then they investigated Cromwell and condemned him. So they were absolutely fearless. Everyone who wanted power in this new society was investigated and condemned by the Levellers, and it was they who produced a new Bill of Rights, the Agreement of the People, which they introduced at the Putney debates. The law shall be no respecter of persons. There shall be no discrimination. It was a wonderful Bill of Rights that they presented. So all these ideas begin in the 1640s, in this crucible period of British and indeed world history. But for all the success, Parliament won the first Civil War. The king was put under house arrest, in fact, castle arrest. It was because there was this great paradox. As someone said to Cromwell, he can beat us 99 times and he's still king. He beats us once and our heads are on the tower. It was an astonishing paradox that the enemy commander was still the king. And then we go through this strange period in the late 1640s where the king is in his castle and ostensibly a prisoner, but he's negotiating with Parliament, with the army, and he's got his own forces in Ireland and in The Hague, and all ready for a second civil war. And indeed, a second civil war there was in 1648, when his supporters rose up and were beaten again by Cromwell and Fairfax. So then came the real issue of how can you set up a new society and government when you have a king who believes he's the absolute ruler and who's just waiting to overthrow you. And so we come to the central subject of my book, the trial of the king. It is a remarkable story. It is the first trial in history of a head of state. And in order to do it, of course, those who, Cromwell and his lawyers, and I talk particularly about the prosecutor John Cooke, had to get over the Treason Act. It was treason to even imagine putting the king on trial. And indeed, when they decided that there was no way other than to try the king, the Inns of Court, where all the lawyers were, emptied. Everyone fled to the country. The Chief Justice fled. The Lord Chancellor fled. They couldn't face up to this enormity of putting the king on trial, as the king was advised by the best lawyer at the time, Henry Bridgman, who was the inventor of the rule against perpetuities, which had tormented law students for many centuries thereafter. And he said, look, you can rely on Magna Carta. Magna Carta requires trial by peers, by your peers, and you're the king, you have no peer. And the king had the absolute sovereign immunity because he was the sovereign. And so how could you put him on trial? And it is to I think, the great memory of John Cooke that he worked out a way to put the king on trial. He found an Achilles heel in the doctrine of absolute sovereignty. It was the argument, it was the crime of tyranny, what we would now call a crime against humanity. He accused the king of tyranny, and his evidence included evidence of how the king after the battles had ordered the torture of prisoners of war, how the king bore command responsibility for pillage, for rape by his French mercenaries, and so he constructed what we would think of as very like the evidence in a modern war crimes trial. In order to try the king, the Parliament, what was left of it, passed a statute. And it's a very interesting statute. It was passed in January 1649 to set up a High Court of Justice. They couldn't find kings to try the king, peers, but they found a lot of mayors and councillors and generals, a court of 70. And in that, they used for the first time, in its modern sense, the word impunity creeps in. It's, the statute says that the king will be put on trial to the end that no king or chief magistrate shall destroy the liberties of the people and expect impunity thereafter. Impunity, the freedom that tyrants should never have to live happily ever after.